Expert testimony is often at the heart of antitrust trials. It frequently involves challenging technical issues such as econometric analysis. With our article, we wanted to help practitioners understand the increasing complexity of expert testimony in antitrust trials and the outsized influence it can have on trial outcomes. We also wanted to share some important lessons from antitrust cases we've tried where experts went sideways for the other side. It all starts with hiring the right expert. The brightest and best credentialed expert isn't necessarily the right choice. It doesn't matter how smart an expert is if they can't connect with judges and jurors. When evaluating expert candidates, we recommend following what we call the 6 C's: credibility, composure, clarity, charisma, confidence, and creativity. Nothing matters more in court than credibility. A commonly held misconception is that a malleable expert is an asset because they'll readily endorse litigation positions, but that's a mistake. An expert should not be perceived as an advocate. Many experts suffer from what we call Dr. Jekyll and Mr. Hyde syndrome. They're the questioner's best friend on direct examination, but become evasive and even hostile on cross. An expert's answer to a question should not depend on who is asking the question. With our article, we also wanted to emphasize the importance of laying the groundwork in discovery for effective trial examinations. We've seen too many lawyers overlook this foundational step. We've watched valuable time wasted in many expert depositions on things like hypotheticals and arguing with experts. Hypotheticals, by definition, are essentially make-believe, and any expert worth their salt will make that clear. Quarreling with an expert is unlikely to create a usable record for effective cross at trial. We've also watched many experts and their counsel squander valuable opportunities in depositions by adopting the do no harm approach. But developing affirmatively helpful deposition testimony from your own expert on key points can prove very valuable later against a Daubert attack and a trial. Also, don't hide bad facts from your expert. Prepare your expert to deal with those in deposition. Surprised witnesses rarely produce good testimony. Remember that not every point of attack warrants inclusion in a cross-examination. An issue that might turn heads in an antitrust conference might leave jurors bewildered, no matter how important it might be to those steeped in the field. A basic point we wanted to emphasize in our article is this: a key question in the minds of jurors throughout trial is whom to believe, especially involving issues they have little to no familiarity with. My primary objective in any trial is convincing the jury to trust me and my witnesses over the other side. Our article is intended to provide some helpful practice points for doing that with experts.